So Charlie Gard, Alfie Evans, Tafida, Raqeeb, Alta, Fixsler, these are all names that you probably will recognize from the media. They were all seriously ill young children whose treating doctors thought it was in their best interest to withdraw life-sustaining treatment from them. In all of the cases, their parents disagreed, desperately wanting to prolong their life a bit longer through further medical intervention. And what followed in all of these cases was a protracted and highly publicised litigation, which in all but the case of Tafida Raqeeb ultimately ended in the child's death. Now, these are just four of many cases that have come before the courts in recent years in which a dispute has arisen between the treating hospital and the doctors over whether or not further treatment should be offered to a child. And in deciding these disputes, the courts have been very clear that it is them and not the parents who are the final arbiters of the child's best interests, and that they retain authority to intervene and to make a decision in any case where the child's welfare is at issue. But as some of the pictures that you can see on this PowerPoint show, these cases have attracted a lot of media attention around the world and a lot of concerns in some quarters about the point at which the courts can make decisions for children, and in particular, the authority of courts to override the wishes of the parents in these decisions about their child's treatment. So thousands of people marched worldwide in protest of Alfie's treatment. And since then, we've seen a number of parliamentary efforts to reform the law in a way that would give greater weight to the wishes of parents in these kinds of disputes. And it's likely that these cases are going to continue to come before the courts, particularly as the internet is increasingly providing not only information about alternative treatments or clinical trials, often in other countries, that simply wasn't available to parents before, but it's also providing ways of raising money and attention in order to get sponsors, which is necessary for parents if they're wishing to pursue these kinds of treatments outside of the jurisdiction. So in the Charlie Gard case, for example, they raised over £1.3 million in crowdfunding in order to pursue this treatment for Charlie, while in the Evans and Fixsler cases, the media attention that surrounded them resulted in interventions and offers of assistance from the Vatican and from the Israeli government. And there's likely to be this increasing international dimension to these kinds of disputes, with parents wishing to take their children abroad to seek treatment elsewhere. And so given the relative frequency with which these cases are coming before the courts, coupled with interest at a parliamentary level, most recently in the Health and Social Care Bill, and of course, interest by the wider public, I think it's important that we ask this question of, are we dealing with these cases correctly? And in particular, is it right that the courts can intervene in these cases wherever they think the child's welfare is at issue? Or should there be a higher threshold for court intervention so as to give greater discretion for parents in these kinds of decisions? And it's that question that I'm going to be exploring in my talk today. So I'm going to begin by briefly setting out what the law is in this area. In particular, what I'm looking at is treatment decisions for very young children. So I'm not looking at Gillick competent children, which raise equally interesting but different issues. I'll then consider the challenge to the legal position in Gard and what that case raised, or what that case revealed about the extent of the court's powers under the inherent jurisdiction. And then I'll go on to consider whether the courts were right to give such sort of short thrift to that challenge, or whether in fact there might have been good reason to embrace this idea that we need a higher threshold for intervention. Just for clarification, I'm talking about the Gard case because the child is called Gard, but if you wanted to look at it, it's actually called Yates. So what's the law? Well, it's long been accepted that although parents are generally entitled to make medical decisions for their child, this is subject to the courts retaining an inherent jurisdiction to substitute its own decision for that of the parents, where this is necessary to promote the interests of the child. And that authority has a very long history. It dates back to feudal notions of parens patriae, which is this idea that the monarch was the parent of the country and therefore had jurisdiction of everyone that inhabited it. In the 16th century, that was then passed over to the courts. And by the mid-19th century, it was clear in Re Flynn that the court had the power to protect children from their parents' decisions, where this was essential to their safety or to their welfare. And that position was then consolidated and developed throughout the 20th century, with Lord Justice Waite making clear in 1997 in Raqeeb that the court had the authority to intervene whenever the child's best interest will otherwise not be promoted. So that's very long-standing and very well-established authority. And in these cases, there's not a lot of scrutiny or engagement with a normative basis for this. Really, the judges in these courts tend to just treat it as axiomatic, well-established principle that the courts can intervene and make a best interest decision for those child. It's also the case that they use welfare and best interest interchangeably, really, in these judgments. So you have sometimes it's referred to as you can make a decision wherever the welfare of the child is implicated or at issue. Other times it's when the best interest of the child is not being promoted. And as I say, that didn't receive much scrutiny until we get to 2017 and the case of Charlie Gard, which for the first time really questioned this legal position and the extent of the court's power under the inherent jurisdiction. Now, in order to understand the challenge to the law in this case, it's important to understand a bit about the facts of that case and why they raised this slightly novel point of law. So Charlie suffered from a rare, inherited and ultimately fatal mitochondrial condition, which had left him unable to breathe or to walk, move unaided, as well as causing him to suffer from serious brain damage. And his treating clinicians from Great Ormond Street wished to withdraw artificial ventilation. His parents objected to this, and they instead wished to take him to the United States to trial a very, very experimental treatment called nucleoside therapy, which they hoped would improve his condition somewhat. In fact, the hospital was initially supportive of this idea and they did seek ethics approval for it. But in the intervening period of time, his clinical condition deteriorated. He suffered from a number of seizures, which led to him suffering structural brain damage, which they didn't think could be improved. And so it was in that context that they thought the treatment should be withdrawn. Now, what was different about this case was that unlike in most of the preceding cases, in some sense, there was no need for the court to be involved in this dispute at all, because in most of the cases that you get up until Charlie Gard, you have a dispute in which neither party can achieve their desired outcome without the court arbitrating and making a decision. So if parents want their child to be treated and the doctors don't wish to offer that treatment, the parents can't force doctors to treat them against their view of what is in their patient's medical interest. All they can do is go to the court and hope that the court will make an order that it is in the best interest of that child to receive that treatment, in which case it is hoped that either the doctors or a different set of doctors will then provide that treatment to the child. And conversely, in conflicts where you have the parents refusing treatment, which the doctors wish to give to the child, in order for the doctors to have legally valid consent, to be not committing a battery, they have to have consent either of the parents or of the courts. So if the parents aren't offering it, they need to go to the court because the court has to provide them that consent. And so in all of these cases, one or other party doesn't have much choice but to go to the court and ask them to resolve this intractable dispute. But this case was slightly different because the parents weren't trying to get that hospital, those treating doctors, to treat Charlie. All they were saying is, that's fine. Well, it wasn't fine, but you don't want to provide this treatment. I want to merely take my child to a different hospital where there is a doctor who is willing to provide it. So in this situation, essentially what you've got is a doctor willing to offer treatment to a child and parents willing to consent to that treatment. So the question then becomes, well, why does the court need to step in and decide and offer their consent or refusal to this treatment? And so this, for the first time, really shone a light on this question of whether or not there ought to be a threshold which must be met before the court could involve itself in these kinds of decisions and decide in the best interests of the child. Now, counsel for the parents in this case, Richard Gordon QC, argued that the court should only intervene where the parent's decision would put the child at a serious risk of significant harm. After all, if the threshold for intervening in these decisions is best interest, then that means that the court can intervene effectively wherever they disagree with the parents' appraisal of the child's best interest, wherever they think it's a suboptimal decision and it's not the absolute best one for the child, the courts could step in. And this would, counsel argued, represent an exceptionally large intrusion by the state into the private decisions of parents, which would be hard to reconcile either with Article 8 or with our common law constitutional principles. And I've included a couple of quotes from Richard Gordon on the slide, because I think it really captures the point he's making, at least before the court of the Supreme Court. The arguments were sort of evolved over the course of proceedings, which is that this is not just a question over the medical treatment of one young and very ill boy, but at its core, it was about the boundaries of legitimate state interference with familial decisions. And in his view, if the line between what the state could or could not do was best interest, was whether that decision was deemed to be best, and that effectively eroded any space for parents to be able to make decisions about their child, which the court disagreed with. Now, the court roundly rejected this argument at all levels of appeal. And when the Supreme Court refused permission to appeal, it didn't explicitly engage with this question of whether a threshold currently exists for intervention. But Lady Hale did say, parents are not entitled to insist on treatment by anyone which is not in their child's best interest. So she seems here to be reiterating this orthodox position that the court has authority to intervene wherever a decision is being taken that does not promote the child's best interest. And the later cases, such as Evans, confirmed that the powers when they had involved themselves in decisions were quite expansive. These included the fact that they had the authority to issue an injunction that would prevent the parents from taking their child abroad. And in the cases that have followed Gard, this position has been reiterated a number of times, and the courts dismissed arguments in both Raqeeb and Evans that the effect of this position was to undermine the children's EU right to free movement under EU law. But despite its widespread acceptance, none of these cases provide a very strong normative justification for this very broad jurisdiction, beyond merely kind of asserting that it's necessary to protect the welfare of the child. Nor do they really engage head on with this argument made by the appellants in the Gard case that this represents a substantial intrusion in the private lives of families. And so for the remainder of this talk, what I want to do is question whether this position is correct and justifiable. Should the courts be able to intervene in any decision, or should there be a threshold over which courts have authority? And it's a question which I think it's fair to say that me and my co-author working on this issue, Professor Charlie Gard, have found really very challenging. And it's one of the reasons why it's challenging is because it really does strain one's commitment to value pluralism and to tolerance of different belief systems, in order to accept, as I think we now have, that we should allow parents to make decisions which we find ill-advised, perhaps even abhorrent, if they aren't harmful to the child. And so one thing I do encourage you to do, if you're looking at these cases, as we go through the issues today, is to really try and reflect on the extent to which your reaction to them is an intuitive response to parents wishing to do things that you find maybe very problematic, like keeping a child on a ventilator for 20 years in a minimally conscious state, which are intuitions which many people like myself have, but which I think we need to be cognizant of when we're thinking about what it means to be a society that truly tolerates different value systems. So the key difficulty with the current approach, in my view, is that it presupposes that there is one answer to the question of what is best for a child, and that the court is best placed to determine what that answer is. But in difficult cases such as this, where you have complex values and issues that you have to balance against each other, factors and interests which are not just medical in nature, but emotional, spiritual, psychological, relational, there may be very many different ways in which you could balance up these different interests and reach a different decision. So there may simply not be one right answer to what is best for the child in these cases, but a number of reasonable but different views on that. So in the case of Alfie Evans, for example, all of the parties fundamentally agreed that his prognosis was probably terminal. The decision was therefore really ultimately about how this small child lived out the final days of his life. His parents wished to take him to Italy, where he would have a tracheotomy, and then he would be continued to be ventilated in the hope that one day he might be able to return home with them to their house. The doctors disagreed, but the question of whether or not it is better to end one's life sooner or prolong it in a state of minimal consciousness is not really a right or wrong answer. It's a value judgment based on a variety of cultural, religious, emotional factors. Similarly, in Raqeeb, the parents of Tafida wished, in accordance with their Muslim beliefs, to do everything possible to sustain their daughter's life, who had unfortunately been left in a minimally conscious state following a bleed on the brain. A respected children's hospital in Italy were again willing to perform a tracheotomy and continue ventilation on them. And she and the parents hoped that this would enable them to take her home, to care for her at home, where she might live for 10 to 20 years on mechanical ventilation. It was accepted by all parties that her position was unlikely to improve. The question was therefore ultimately about the value of her continued life and about when, how, and where she would die. And one of the interesting dimensions to this case, which really brings out this point, is that in Italy, they have the same legal tests as we do. They have best interest tests. The only difference is that when they weigh up the factors in their best interest tests, according to their jurisprudence, they effectively place more value on the sanctity of life, such that they won't deem it to be in the best interest of a child to have treatment, life-sustaining treatment withdrawn, unless that child is suffering from brainstem death. So you've got, in essentially the same here, a different country effectively striking a different balance when it comes to best interests. So arguably then, these disputes are not really medical disputes, but they're value disputes about the value of life with profound disability, about which kinds of chances are worth taking at what cost, or about which benefits justify which burdens. By their very nature, they therefore permit of more than one legitimate view, precisely because they entail these very personal, subjective questions. So as Alexander Kahn once said, deciding whether the outcome of care will be a fate worse than death is a deeply personal matter. There is no right or wrong answer. And where a dispute is fundamentally one of value, then it might be right to accept room for reasonable difference of opinion, depending on the ethical framework adopted and the value ascribed to the inherent good of the continuance of life. And the fact that these involve these subjective values was acknowledged by Mr. Justice MacDonald in Raqeeb when he noted that contexts like this really place stress on the best interests test, because absent pain and suffering, the answer to a child's best interest must be looked at in subjective or highly value-laden ethical, moral, or religious factors, which mean different things to different people in a diverse, multicultural, multi-faith society. And it's certainly notable that in many of these cases, there's a religious component or dimension to it. So in the case of Raqeeb, clearly Tafida's Tafida's parents were devout Muslims. In Evans, Alfie's parents were Roman Catholics. In Alta Fixsler, they were also ultra-Orthodox Jews. And in Isaiah Hastrup, you've got Pentecostal Christians. So there is an argument coming through in lots of these cases by the parents to say, well, it is for God and not the doctors to determine when someone will live and when someone will die. And my child ought to be able to live in accordance with my or their religious doctrine. But once it's accepted that there's not one verifiably right answer to these questions and room for reasonable disagreement, the question then becomes, well, whose perspective on what is better for the child ought to take precedence? Under the current law, it is the court's perspective, their assessment of what is in the best interest of the child, which is ultimately decisive. And that will often, though not invariably, coincide with that of the doctors. But beyond the obvious point that doctors are emotionally detached from the situation and arguably more objective, we still might ask why they're better placed or best placed to make those decisions and decide what's best for a child, given that they have neither the medical expertise of the doctors nor the unique relationship with the child that parents have. And I certainly think that there is a strong case that could be made for why parents could be best placed to determine their child's interests. After all, it is parents who arguably know their child better than anyone and who have the deepest personal interest in their well-being. And that might make them best placed to know what their child's needs and preferences are, what they might value, or importantly, what they might be able to tolerate. It is also the parents who will ultimately bear the consequences of these decisions. And it will be them who care for their child through the agony and demands of treatment or non-treatment. And the decision may impact not just the child, but also the wider family, and they are better placed to balance these familial interests. So there's good reasons to think that the parents might be at least as good, if not better than the courts, at understanding and balancing the child's often competing interests. And the parent's insight might be of particular value when you're trying to work out how to balance medical considerations against other interests, as will often be the case where you're deciding whether or not to continue to offer invasive medical interventions to a child who perhaps is unlikely to improve, or the benefits are not as clear-cut or extensive. We might also say that if we don't think that we can say for sure what course of action is best for a child, and there might be different perspectives on this from different people involved in that child's care, then an approach that prioritizes the parent's perspective better protects plurality of values. So in a liberal democracy committed to freedom of thought and to tolerance of different value and belief systems, there may be good reason to permit parents to make choices, and even if this causes them to act in ways that we would not. And I think Rob Hayward is correct to say that if the law is to take seriously the values of freedom of religion, expression, and the right to respect for private and family life, it must attach genuine significance to medical decisions which are underpinned by those values. Arguably, it's exactly in these kinds of cases where we don't have a clear-cut right or wrong answer that commitment to pluralism becomes meaningful, even if the consequence and the sort of unsavory consequence of that is that we have to allow people to make decisions that we consider to be problematic based on values that we cannot accept or endorse. In medical decisions, as in other decisions, therefore, it might be important to leave space for reasonable disagreement by creating a zone of discretion for parents to make these kinds of choices free from interference according to their own value and belief systems. Now, that is not for one moment to suggest that parents should have these unfettered rights to decide whatever they want in accordance for their child. Clearly, there should be some kinds of limits on the kinds of decisions that parents can make. For a start, not all decisions are purely value-based. They also have a fact dimension, and it's possible that the parents may make errors of fact, which the child must be protected from. Even if we know answers of fact, parents may also not accept those facts as they're presented by the medical professionals, such as a terminal diagnosis or whether or not a child can experience pain. And that may lead to decisions being made that without this strong factual basis. And this was arguably the case in the Hastrup decision, where the parents simply couldn't accept that he couldn't be weaned off the ventilator. But also in the Fixsler case, where the parents expressed some doubts about whether or not their child was able to experience pain. The medical professional's view was that she could experience pain, even if we didn't know exactly how she felt it, that she was responding to painful stimuli, whereas the parents did not believe this. And of course, parents are in this difficult position where you're trying to understand your child's needs and experiences, but they're in a state of often profound brain damage. So clearly in these cases, there is a need for court intervention. A parent can't claim a right to be wrong in these cases. There may also be cases where, marred by the emotions of having to come to terms with the loss of their child, parents make irrational or harmful decisions for their child, which expose them to unnecessary pain and distress. And again, clearly the state has a role here in protecting these very vulnerable citizens from avoidable harm. The question is really about how we walk this line between, on the one hand, respecting plurality of values, and on the other hand, protecting these highly vulnerable children's interests. And arguably, an approach that allows the courts to intervene wherever they disagree with the parent's assessment of the child's best interests is going too far in one direction. It's failing to create sufficient space for different value systems and medical decisions that are underpinned by those different value systems. By contrast, a threshold in which parents' authority yields only where their decision places the child at a serious risk of significant harm, as was argued for in the Gard case by counsel, protects a zone of decision-making for parents, allowing their view of what is best for the child to take precedence or to be followed, providing that that is not significantly harmful to the child. And I think it's important here to be clear about what people who are advocating a significant harm threshold are really saying from a kind of conceptual point of view. Because it's often suggested that those people who support a harm threshold are essentially suggesting that parents should be allowed to make all these suboptimal and welfare-reducing decisions, provided that they're not harmful. And that's what I'm trying to show in diagram A, that you've got this space in between the best interests of the child and the harmful, and we let people do whatever they want within that space. And certainly it's the case that those people who are advocating for stronger authority for parents and I suppose a more slimmed down role for the courts are likely to be more willing to tolerate suboptimal decisions by parents. And of course, we do tolerate those suboptimal decisions in every other area of a child's life. You know, we don't step in and stop parents from feeding their children fizzy drinks or giving them unconstrained internet access unless we think that that's gone to such a level as to be harmful to them. But in my view, that this way of looking at things doesn't quite capture the full force of the point, because it fails to recognize our inherent epistemic limitations. So the way of looking at this presupposes that we know what's best for them, and so we're effectively indulging parents by allowing them to make all these suboptimal choices, even though we know what will be best for them. But the reason that many people advocate a significant harm threshold, or some people advocate it, it's not that many people, at least in the legal world, is precisely because, or is a recognition that we don't know what is best for the child in these kinds of situations, because there's room for reasonable disagreement. And so because we can't say with certainty, yes, that's the best choice for the child, we should instead permit this sort of zone in which parents can choose what they think is best, provided that it is not significantly harmful to the child. And I've tried to capture that in diagram B, admittedly with my slightly budget IT skills. But the idea is that there isn't a straightforwardly optimal choice for the child, but a range of different decisions that could be made, which may or may not be the best, but they are not significantly harmful. So what are some of the reasons in support of this, of a harm threshold, which I would add, despite the fact that it gets relatively little traction in the legal literature, in fact has a vast amount of support in the biomedical ethics literature, where there's near consensus that it represents a better threshold because it operates a better middle ground between plurality of values and protecting the child's interests. Well, one of the benefits is that, in my view, it would better accord with public expectations about where the law ought to be, or what the law ought to be, and provide a clearer basis for intervening in these kinds of decisions. It would also be consistent with the threshold that is applied in the care context under the Children Act 1989. So there, section 31 says that a court cannot make a public order placing a child in the care of or under the supervision of a local authority unless it's satisfied that the child is suffering or is likely to suffer from significant harm. So it would bring these two in line. And I don't think consistency is in itself a good enough reason, but I do think it is an argument in support. Therapist Ikema has also made the point that harm may be better understood by clinicians, possibly also judges, though that's questionable. And so it might represent a less opaque threshold for parental discretion, thus garnering greater consensus. The idea is that it might be easier for people to agree on and to say something is harmful than it is to say that something is best. But importantly, such an approach might be better, more accurately capturing what's going on in some of these cases. So in Raqeeb, for example, it's notable that a lot of Mr. Justice MacDonald's judgment focused on the lack of harm to Tafida, who couldn't experience pain or have any awareness of her situation. And it was against that backdrop that he decided that the potential benefits to her in terms of being able to be cared for at home by her devoted family and living in accordance with these cultural and religious upbringing outweighed the burdens. The opposite conclusion was reached in Gard and Evans and in Fixsler, in all of which it was thought that the child was potentially able to experience pain and discomfort, which resulted in the conclusion that treatment shouldn't be pursued. So in Gard, for example, Mr. Justice Francis was clear that it was in Charlie's best interest to let him slip away peacefully and not put him through more pain and suffering. Well, much of the analysis in the Fixsler case boils down to this question of whether or not she can experience pain or not. So it might be, if a lot of these cases are hinging on the extent to which the child is thought to be being harmed by that choice, then a harm threshold may actually more accurately capture what is in fact underpinning the judgments in these cases, with judges giving more leeway to parents in the absence of harm. There is also empirical and anecdotal evidence by people like Giles Birchley and Dominic Wilkinson that indicates that really doctors are very resistant to bringing these cases to court at all, unless they perceive there may or may not be, but they perceive there to be some harm to the child. Finally, a risk of significant harm threshold might, and this is a might, also strike a better balance under Article 8 of the European Convention on Human Rights. So that right protects the right to respect for private and family life. Now, of course, that is a qualified right, and it's qualified when necessary in a democratic society for, amongst other things, the protection of health and morals. But it's at least questionable whether intervening on the basis that the decision is not the best one for the child is necessary to protect their health. So in the case of Judgen in UK, for example, the European Court of Human Rights said that a restriction on convention rights cannot be regarded as necessary in a democratic society, two hallmarks of which are tolerance and broad-mindedness, unless, amongst other things, it is proportionate to the legitimate aim pursued. But if the aim pursued is protecting the health of the child, then it's at least arguable that unless the child is being harmed unless their health is being harmed in some way, or the welfare is being harmed by the parents' decisions, this goes further than is necessary to protect their health. So it might be that it strikes a better balance under Article 8. That's not to say that it's incompatible with Article 8, and we know from Gard in UK that the court didn't find it to be so, but it certainly might secure a better balance under Article 8 and show more respect for the rights of freedom of thought, conscience and religion under Article 9. But given the evidence that both doctors and the courts may already be applying an implicit harm test, you might say, well, what's the point then? Why do we need to bother reforming the law and introducing this new explicit harm threshold? And that's especially the case given that clearly in order to reform this law, it's not just the case of changing a statute, but it's also going to involve the establishment of a new body of literature on what constitutes significant harm. Now, we can, of course, draw on the jurisprudence that exists in the care context, but still we'll need to do more work refining both the concept of harm and when it will amount to being significant harm. And that's not always easily answered. So, pain and distress, for example, is more easily identified, tested for, quantified than other ways in which more intangible ways in which someone could be harmed. And yet even then, the case law suggests that in the context of very brain damaged very young children, it may be very difficult to establish whether they feel and how they experience pain. Meanwhile, there are many other ways in which people might experience or think of as being harmful, which are much more intangible, like causing distress to others, or being forced to live in a way that goes deeply against your deeply held religious values. And indeed, there is already some discussion in the case law about what harm means and when you can experience harm. Some people have also raised the concern that it might be worse for parents, because there's a more explicitly negative evaluative undertone to saying to a parent, you're harming your child, than to say you're not acting in their best interest. Now, of course, that is an empirical question, whether or not it will in fact be worse for parents. I have to say, I'm a little skeptical about it as an argument, both because maybe it's the lawyer inside me that doesn't like the slightly airy-fairiness best interest, but I'm not convinced that I would find it easier someone telling me you don't know what is best for your own child, then I'm sorry, you can't do that because you're making a decision that we think is harming your child. I'm just not convinced that is necessarily much worse, but also because the results in these cases are so profoundly awful to the parents, because most of them involve the withdrawal of life-saving treatment. That while I appreciate the importance of language, I'm not sure whether or not the phraseology that's used mitigates the horror of having your child's life ended against your wishes. But finally, and I think most importantly, the criticism that might be made against this suggestion to move to significant harm is that it might be questioned whether or not we need to, given that cases like Raqeeb indicate that there is scope within the best interest test as it stands to account for different of value and to give and accord weight to parental perspectives on their child's best interests. So if we can do it under best interest, why do we need to move to a harm threshold? And I think that's a perfectly valid response, but I still think that a shift would be beneficial for two reasons. The first of these is that if you look at the case law, not all judgments attach the same importance to parental perspectives and to accounting for value differences as Raqeeb. So unlike in Raqeeb, in Evans, there was very little discussion of the need to encompass different value systems within best interest, nor was there any direct engagement with the fact that there could be space for reasonable differences of opinion over whether it's better to live a longer, a longer life in a disabled condition or to end it quicker. And in fact, by describing the parent's position as irreconcilable with Alfie's best interest, Mr. Justice Hayden seemed to imply that there is a single objective answer to what is best, which, as I've said, I'm not sure there is. Ultimately, despite the clear similarities between the Evans case and the Raqeeb case, you've got completely different outcomes. In one case, the court authorises her to go to Italy to receive this care. In the other case, treatment is withdrawn. So while it is possible to accommodate it within the best interest test, it's clear that it's not always being accommodated. And so there might be value nonetheless to ensuring greater consistency in the judgments, which have a more clear and transparent way of accounting for value differences. But also because even if there isn't much change in practice, I think it's still important that you're clear and transparent with parents in these cases about why someone other than them may decide their child's fate and on what basis that decision is being overridden. There could scarcely be a more important or fundamental decision than one about when we decide to end a child's life. And in that context, that transparency, I think, is absolutely key. It's key for the parents. It's also key that whilst it hasn't always been positive, that there's scope for good public scrutiny of these kinds of decisions. So where does that leave us? Well, as I said at the start, it's not an easy question, and it's one that we were very conflicted on for a very long time. When making a best interest decision for adults or for older children, it's a lot easier because the patient has held or expressed values that you can use to inform your assessment of what is best for them. But with very young children, particularly very young children who've been very ill for a very long time, judges are faced with a vacuum. that must be filled by one set of values or by another. And the question of whose values ought to fill that vacuum and of what limits there should be on parents imposing their value systems on their children is far from straightforward. So for the reasons I've given, in my view, just about, where there are multiple legitimate or reasonable answers to the question of what is in a child's best interest, the law ought to leave space for reasonable disagreement between doctors and parents by creating a zone of discretion free from interference, where parents can make these kinds of decisions, providing they are not harmful. I think this would better account for legitimate differences of value, but it's a contentious and difficult issue. And so I'm going to stop now in order to leave plenty of time for people to give their views on whether or not they think the law is satisfactory or whether they would like to see it changed. Thank you.
I don't have any questions in the chat just yet, but I'm sure people will be sending them in. But if anyone in the room has any questions, please do shout it out. Yes. If you shout loud enough as well, I might be able to be caught on the speaker, but I might ask Cressida to repeat.
I have a question. So following the risk-specific harm threshold, do you think it's likely that cases like Evans and Gard would have been decided differently, and do you think that has to do with that?
So it depends on the case. Of course, I can only go off the evidence as it's presented in the judgment. So the judge's appraisal of the evidence. I think in the Gard case, it was a case where there seemed to be clear evidence that there probably would be harm to the child. So I think it wouldn't have made a difference in that case. I think the Evans case, it potentially would have made a difference. There was less clear-cut evidence about the kinds of harms that he would be capable of experiencing. The Fixsler decision, I think a lot of it rested on this idea of whether or not she could feel or experience harm and the distinction between experiencing and feeling harm. So it's difficult to say with that case whether it would have made a difference, but it might have made the focus of the judgment more, it might have changed the focus of the judgment, but ultimately the decision in that case was made that she could experience some kind of pain. She responded to painful stimuli. So I think, again, that one would have been one that the harm threshold probably wouldn't have made a difference, whereas Evans and Raqeeb, I think it could have done.
Thank you. Someone's agreed that a change to threshold significant harm is good. But,
oh, thank you very much. It's rare to have people agreeing with you.
Any more questions in the room? What do you throw it out there?
I suppose I should ask the question. Should I declare who I am? I'm a judge in some of these cases. I'm Jonathan Baker. A fascinating tool and really well presented out.
Thank you.
I'm just going to ask the question which has just been asked, which is what cases do you think it would have made a difference? I'm interested in made a difference in Evans and Raqeeb.
Well, Raqeeb, I think, would have been decided the same way. So Evans is the clearest. Hastrup, it might have made a difference, but it was a slightly different fact pattern because they didn't have anyone else offering the treatment to him. So his position wasn't one that I think they thought he could experience much pain, but he didn't have a doctor abroad that would have offered him the treatment.
So can I just share some thoughts and see what you think? First of all, you put the word serious into your test at some point, or the line in bold, which I thought was quite interesting. Serious risk of significant harm. So I'm thinking, how does that fit in with, for example, the test under Section 31 Children Act, where the word serious doesn't? That's the first one.
Yeah.
The second one is, you haven't mentioned a concept which appears in all these cases, which I have found problematic, which is dignity.
Yeah.
And how does you feel? I'd be interested in how you felt that fits into it. And the third question is, can you through?
Yeah.
The third question is, what was the point? Ultimately, and it's never mentioned in public, but it's definitely a factor in some people. It all comes down to money. We won't hear is mentioned, and I'm sure it doesn't inevitably. And the fact is, it costs an enormous amount of money to keep children alive. And what part do you think that plays, if any? So if you think that plays any part of anybody's thinking about this, and what can you do about that if it does?
Yeah, so I think you're right, the money does play a part in it, and clearly there are profound implications, and these litigations have profound implications. Like, you know, the Gard litigation went on for months and months and months, during which time he was in neonatal intensive care. Well, an average child's stay in neonatal intensive care is 7 days. So during that, while that litigation goes on, you've got a child receiving this care for a very long time. And clearly, if you decided to, if you didn't withdraw treatment, then that would go on for even longer. I suppose what I'd say is that this only has traction in cases where you have an alternative doctor who's willing to provide treatment. And I think it is fair to say, well, you know, that cost can't be borne necessarily by the NHS if you want to do something that we don't think that there's any clinical merit to. But in most of these cases, in all these cases, and that's the difference with the Hassard case, because no one was willing to fund it, in all of these cases, they have the right sources of funding for that. And I think, you know, within that context, where you have people who are willing to privately fund this, often using, admittedly, you know, using the media attention in order to get the funding, in order to do this, I think in those cases, if you don't have doctors who are willing to provide it, and none of the NHS doctors are willing to provide an alternative treatment course to you, then I think then in that circumstances, I think you're right that we can't force the NHS to keep you alive at public expense. With regards to dignity, I didn't mention it because I have to say I don't have a lot of time for the concept of dignity. Not because, well, I think that it's a very useful concept in these cases. And the reason why it's not a very useful concept is because it's very subjective and value laden. So I might think that keeping a child in a minimally conscious state alive on a ventilator for 20 years is profoundly undignified for them. But Tafida Raqeeb's parents clearly didn't. They thought that being able to live, being able to keep their child alive showed the ultimate dignity and respect for that child. So I don't think it helps resolve these cases, because I think it's merely a different way of reframing the debate. One side thinks it's dignified to keep someone alive, the other side thinks it's dignified to end their lives. And I think quite often dignity is used in this case to grapple with, or to, I suppose, maybe label or fudge a intuitive feeling of discomfort about some of these parents' choices, where we can't pin down exactly why it is that we find it problematic. For example, if you don't think that a child can experience pain, why do you feel so, and therefore can't be, in an experiential sense, harmed by a course of action? Why do you find it so difficult to accept that they'll just be kept alive on a machine for the next 20 years? I think dignity is just a way of capturing an intuitive sense of sort of repulsion or unease, which isn't kind of conceptually very transparent or particularly analytical. I think it's a bit of a fudge. It's like futility. I have objections to the concept of futility, again, because it's a label that we use that obscures the exact reasoning that belies it. And what was the third?
I was interested by your use of the word serious.
Oh, the serious risk of significant harm.
So that's a
higher threshold, yeah. I mean, so that's one that I'm still not sure of, actually, whether it should be just risk of significant harm or serious risk. The difficulty is how you apply it in cases where there's always a risk in any of these cases. The doctor's evidence is never 100% sure. They're never 100% sure that the child can't experience pain. Or that the child is going to be, all of their prognoses, it's never 100%. And so the risk, I suppose, risk with just having risk, is that you could make it apply in any case, because all you have to say is that there is a slight risk that they could be able to experience discomfort or distress or pain. And then you bring it within the realm of risk of significant harm. So the point with the seriousness, or the serious, was to try and stop it just falling into the position where it is now, by creating a slightly higher threshold, that you have to have a higher evidence base that there is some harm that's going to result. But I'm still not sure about it, because it still then leads to the question of how serious does that risk need to be in order for the court then to intervene.
Doesn't the word significant do that?
Well, I think the seriousness goes to the risk, whereas the significance goes to the harm. So the significance is important because when you're thinking about these kinds of medical interventions, of course, there's always some harm, because every time you put a child in neonatal intensive care, there's some harm to them. It's just that we think that harm is outweighed by the benefits, that they'll usually get better. So they often have to have suctioning and and heel pricks and horrible things done to them. So the significant is capturing the fact that the harm, the harm has to be reasonably serious. It has to be proper harm, as opposed to just a small level of discomfort that anyone who undergoes any kind of medical intervention will have. But that goes to the harm as opposed to the risk.
Got a question from Teresa online. I'm just going to read it out for people in the room. Do you think there is much rhyme or reason to why there is such a difference between these young child cases and adults without the ability to consent or understand treatment?
Why there's such differences? Well, I mean, I think the key difference between the cases is the extent to which you have anything to go off in order to grapple with what's best for them. The reality is, where you're talking about a profoundly brain damaged child who's always been brain damaged since they were, since birth, you've got very little to go off in terms of determining what they would want in that situation. They've not expressed any views. They've not even experienced any of life in order to have a view themselves. So the key difference is that in those cases, the judge is kind of going blind when they're determining what's best for them, and they have to decide to what extent we essentially view them as in a sense, an extension of their parents, and we let their parents' values be what informs that best interest assessment. Whereas with the adults, they have, they very often, in most cases, they will have expressed views, either in the cases of someone who has dementia or a mental illness or has a brain injury, they will have expressed views before they lost capacity. And certainly in recent case law, there's been a lot of work that's being done by the judges in trying to ascertain, based on previous conversations and previous interactions, what they would have wanted. Or if there's someone who has a learning disability that they've had from birth, generally you're able to get some sense of what things would make them fearful, what things would cause them distress, what level of pain they'd be able to tolerate, what level of understanding they'd be able to have about the negative sides of their treatment, which can inform how you make that best interest assessment. So I think, in a sense, there are much more there's criticisms that I would make of certain ones of them, but I think there's much more to go off. And so they're probably a much more individual-centric assessment than in relation to children, where there's very often almost nothing to go off. The best point of evidence in Tafida Raqeeb's case, for example, about her values was that she didn't kill flies because she was 5, and she's like the older end of the spectrum, and that's still not very firm evidence to indicate what someone's views on the sanctity of life would be.
Thank you. I have another question online from Ben. I'm just going to read it verbatim. Does Dr. Auckland believe that there may be scope for a medical ethicist to work alongside the courts to offer advice on the ethical implications of the decision?
Yeah, I mean, certainly this is something that medical ethicists think will help. Do I think it would help? I think it might help. I think there could be scope, and it might help. The difficulty is reconciling the ethics of approaches with the procedure that's required in law, and to ensure that things are procedurally fair, because an ethicist might have all sorts of views about what the right ethical outcome is, but if that's not an argument, if those are not the arguments that have been put before the courts and which the parties have presented and had the opportunity to rebut, then there could be procedural points. But I think it would certainly help inform some of these judgments. Yeah, I think it's generally a positive view. I wouldn't go quite as far as to favour what some people say in terms of using clinical ethics committees instead, but I think an ethicist advising could be beneficial.
Another point from Caitlin. Do you think mediation with doctors and families could potentially address the issues rather than relying on courts?
So I think that mediation could be really helpful, and there's lots of pushes to enhance mediation in this realm. And for example, recent bills before Parliament, including access in the last parliamentary round, which ran out of time, tried to make mediation a compulsory first step of going before the courts. I think the value of it is in part that these positions can become so entrenched as the dispute gets further and further, that it can be hard to, you lose sight of the child in the middle of this and the room for compromise. The difficulty I think that mediation faces is that medical decisions of this kind are not ones where there's that much room for compromise. So if you're deciding a divorce, for example, and how you distribute assets, there's a lot of space to say, okay, well, you get the car, but I get the dog, or whatever it may be. Whereas there is some scope with peripheral issues, like whether or not someone's a child could go home to have palliative care there. But for the most part, you're looking at cases where essentially either the medical intervention is performed, in which case the child lives, or the medical intervention is not performed, in which case the child dies. And so within that context, I think it can be hard to find room for compromise because ultimately either the child lives or the child dies. And certainly, you know, there have been mediations. Things like the Gard case, there was mediation, but it just failed because you just couldn't reach agreement. So I think it can be useful, but I also think that there are limits to how much space there is for compromise in these kinds of cases, which undermines how useful mediation can be.
I have one or two more questions in the chat. If anyone in person has a question, please shout out. I'll end in the next 5 minutes or so, I think, so that we don't overrun. But this person's asking, is it family lawyers or other lawyers who argue these cases, and does it make a difference?
So it's a really eclectic mix of lawyers who argue this case. It's in part because they litigate. So lots of these cases in practice, the legal representation is pro bono. So it is in part who is willing to offer. And indeed, what you often see is changes of legal teams throughout the course of the litigation, because well, there are two reasons, but one of them is parents being upset that they didn't win in the first round. But the other is, as it gets further and further, often what you see is the initial team backing out, or the breakdown of relationships between them, and then you have more ideologically committed lawyers, potentially is the way to put it, coming in at a later stage, who represent them in later proceedings. So you get a mixture. So Richard Gordon, for example, is more of a public lawyer. In lots of the cases, you have a team by 39 Essex. They appear in many of them, sergeants in, who are more medical specialists. So I think it's quite a big mix. Do I think it makes a difference? I do think it makes a difference, but I think it's quite a positive thing, having quite a wide range of perspectives on it, because I think, for example, things like Richard Gordon's arguments before the Supreme Court in Gard, which really framed it as an issue about the relationship between the state and the family, would be much less likely to come from a family lawyer than it might do from a public lawyer. So I think that it is quite positive that you get lots of different people with slightly different perspectives. Again, in Tafida, in the Raqeeb case, you had David Locke, you see, who does a lot of NHS law, but also EU law. And before that, in Evans, again, EU law specialists coming in. So you get a lot of different arguments being made and a lot of different perspectives, which I think wouldn't be made if you just had exclusively family law judges or family law barristers.
Great, thank you. If there's any more questions, I will pass them on to Esther later. But at the moment, I think it's best if we wrap up, because we are hitting time, if that's okay. I'm just going to ask if everyone could give another round of applause for Esther.
Thank you very much.